Hello and welcome. Today we're going to talk about the crucial role of fiduciaries and the evolving landscape of legal obligations, specifically in light of recent legal cases and significant legislative updates. Over the past few years, the regulatory environment surrounding group health plans has undergone notable transformations. With the Consolidated Appropriations Act and the transparency and coverage rules now in full effect, fiduciaries are faced with unprecedented challenges and responsibilities. Before we look at the current Johnson & Johnson legislative highlights and the impact of the Consolidation Appropriations Act, or CAA, we will start with the basics of responsibility of fiduciaries, the different types of fiduciaries, and fiduciary best practices. A fiduciary is an individual or entity entrusted with the responsibility to act in the best interest of another party, placing the interests of the beneficiary above their own. This relationship is characterized by trust, confidence, and a duty to act with a high standard of care. Fiduciaries are legally and ethically bound to make decisions that prioritize the well-being of the beneficiaries and to avoid conflict of interest. Roles and responsibilities. Fiduciaries can assume various roles, including trustees, financial advisors, executives, attorneys, or really anyone with the authority to make decisions on behalf of others. Their responsibilities may include managing assets, making investment decisions, or overseeing specific aspects of a person's or organization's affairs. Fiduciaries are subject to legal and regulatory obligations that dictate their behavior and require them to act prudently with loyalty and in good faith. Failure to fulfill these duties can lead to legal consequences. Fiduciaries must act with undivided loyalty to the best interests of beneficiaries. This means avoiding personal conflicts of interest and not exploiting the fiduciary relationship for any type of personal gain. Fiduciaries are required to exercise a high level of care, skill, and diligence in carrying out their responsibilities. This includes making informed and prudent decisions, considering relevant information, and staying informed about industry best practices. In the context of financial fiduciaries, such as trustees or investment managers, there is often a duty to diversify investments to manage risk effectively. This involves spreading investments across different asset classes to minimize the impact of poor performance in any one investment. And finally, fiduciaries are obligated to maintain confidentiality regarding the affairs of the beneficiaries, ensuring that sensitive information is not disclosed without proper authorization. Next, we'll explore various types of fiduciaries, individuals or entities entrusted with acting in the best interest of others. Understanding these roles is crucial for recognizing the diverse responsibilities and obligations that fiduciaries carry. The first is trustees. These are individuals responsible for managing assets placed in a trust for the benefit of beneficiaries. They must administer the trust according to its terms, invest assets prudently, and distribute income or principal as specified. Financial advisors provide investment advice, financial planning, and asset management services. Fiduciary financial advisors are obligated to act in the best interest of their clients, prioritizing their financial well-being. Corporate directors are individuals elected to the board of a company representing the shareholders' interests. They must act in the best interest of the company, make informed decisions, and exercise care and loyalty in their roles. Attorneys, specifically in certain legal contexts, can act as fiduciaries for their clients. They're obligated to prioritize client interests, maintain confidentiality, and avoid conflicts of interest. Executors or personal representatives manage the estate of a deceased person. They must settle the deceased affairs, distribute assets to their heirs, and fulfill the terms of the will. Investment managers oversee and make decisions regarding investment portfolios on behalf of clients. They are responsible for making informed investment decisions aligned with the client's goals and risk tolerance. Administrators manage retirement plans such as 401ks, ensuring compliance with regulations. They act prudently, diversify investments, and act in the best interest of the plan participants. As fiduciaries, adherence to high standards and best practices is essential to fulfill the duties effectively. If you are a fiduciary, make sure you familiarize yourself with the specific fiduciary duties associated with your role. Understand the legal and regulatory framework governing your responsibilities. Be sure to act in the best interest of beneficiaries. Your paramount duty as a fiduciary is to act in the best interest of those you serve. Avoid conflicts of interest and always prioritize the well-being of beneficiaries. Make decisions carefully. Make sure you're considering all relevant information. And if applicable, make sure to diversify investments to manage the risk effectively. Fiduciaries must maintain confidentiality regarding the affairs of beneficiaries, uphold a high standard of professionalism and ethical conduct. Make sure that you are always monitoring and reviewing the performance of assets and the fulfillment of the fiduciary responsibilities, as well as keeping up to date on industry best practices, any legal changes, and market trends. Make sure you are clearly conveying goals, risks, and expectations associated with your fiduciary role. Maintain detailed records of decisions, actions, and communications. Ensure that documentation aligns with the legal and regulatory requirements. And finally, if you are faced with complex issues, consider seeking professional advice. Consulting specialists can help mitigate risks and enhance decision making. Now that we've gone through the basics, let's get to the real reason we are here today, to shed light on the Consolidated Appropriations Act 2021 and the significant responsibilities it has assigned to employers. Let's dive into the key aspects shaping the landscape of employer fiduciary duties. The CAA is an important legislative development, and it's expanded the Employee Retirement Income Security Act of 1974, also known as ERISA. It's intensified the fiduciary responsibilities of self-insured employers. These responsibilities extend to the healthcare services they acquire for their employees. While the assignment of fiduciary responsibility is not new, the CAA has amplified its scope. Employers are now mandated to demonstrate that the healthcare services they obtain are not only cost-effective, but also of high quality. The CAA emphasizes alignment with mental health parity and pharmacy benefit requirements, introducing a new dimension of employer obligations. In addition to these responsibilities, employers are now required to evaluate the compensation of brokers and consultants for reasonableness. The evaluation adds a layer of scrutiny, prompting employers to assess whether the compensation aligns with industry standards and expectations. The CAA's language, specifically on quality and reasonableness, remains somewhat vague. Many employers are still navigating their way through the legislative changes and are taking a cautious approach to compliance. On the other hand, the CAA's requirements on mental health parity and pharmacy spending disclosures are expected to drive employers to intensify their focus on behavioral health and pharmacy benefits. This includes a closer examination of quality and cost efficiency of behavioral health benefits and increased scrutiny of pharmacy partners. Furthermore, the dual focus on quality and cost control may lead to an uptick in disruptive benefit strategies. Reference-based pricing, centers of excellence, and individual coverage health reimbursement arrangements could gain momentum as employers seek innovative solutions. It's crucial to keep an eye on the outcomes of lawsuits, as they will help shape the impact of the CAA. Lawsuits are going to play a pivotal role in defining terms like reasonableness and influencing how parties involved, including employers, brokers, consultants, and health plans, navigate their fiduciary responsibilities. To wrap up this slide, the CAA has ushered in a new era of employer responsibilities, prompting careful consideration of potential shifts in benefit strategies. As the landscape evolves, staying informed and adapting to these changes will be key for employers. Speaking of lawsuits to keep an eye on, I now want to bring your attention to a recent development in the corporate world that carries significant implications for employers and their fiduciary responsibilities. Johnson & Johnson, a prominent drug manufacturer, now faces a class action lawsuit, not in its usual capacity, but in its role as an employer and plan sponsor. The class action lawsuit has been filed against J&J, alleging a breach in fiduciary duties and its oversight of the company's health plan. This suit contends that J&J failed to ensure that its plan costs were reasonable and exercised imprudence in selecting its pharmacy benefit manager while agreeing to unfavorable contract terms. The crux of the allegation is that J&J mismanaged its employees' drug benefits, leading to significant overpayments for certain drugs. Specifically, the lawsuit points to drug costs, asserting that J&J's mismanagement resulted in employees overpaying for prescription drugs, leading to financial repercussions such as higher premiums, deductibles, coinsurance, copays, and even lower wages. What makes this lawsuit significant is that it is not an isolated incident. It serves as an early example of what's expected to be an uptick in class action suits against employers for breach of fiduciary duties concerning their health plans. Law firms are turning their attention to large employers, investigating whether they act in the best interest of plan participants, exercise prudence in service provider selection, and ensure reasonable plan costs. This underscores the importance of robust ERISA fiduciary governance. While these fiduciary duties apply broadly to any ERISA-covered employer providing welfare or retirement benefits, recent transparency laws have heightened scrutiny, especially in the realm of health benefits. The J&J lawsuit, although centered around seemingly egregious drug costs, sheds light on broader issues. Pharmacy contracts, often based on aggregate discounts rather than drug-specific ones, are coming under scrutiny. Employers must not only scrutinize the specific allegations, but also the overall impact of their contracts. To minimize risk and adhere to fiduciary obligations, employers should consider forming health and welfare benefit committees. These committees can monitor ERISA benefits, review service provider contracts, ensure value for the price paid, and oversee aggregated costs. Demonstrating a prudent process through committees can be a helpful shield against potential lawsuits. Diving into the J&J lawsuit, it is crucial to understand that ERISA plan sponsors, as fiduciaries, must ensure reasonable plan costs and exercise prudence in service provider selection. Recent transparency laws have intensified scrutiny on the reasonableness of drug and health plan costs. The lawsuit against J&J highlights specific examples of alleged mismanagement, pointing to a particular drug with a cost disparity of over $10,000 under the J&J health plan, compared to less than $30 at some pharmacies. This draws attention to the need for careful oversight in ensuring the reasonableness of costs and transparency in service provider contracts. ERISA plan fiduciaries have specific duties, including acting solely in the interest of participants, defraying reasonable plan administration expenses, and performing duties with care, skill, prudence, and diligence. Vigilance in monitoring service providers is essential to ensure adherence to contract terms and written plan terms. Failure to uphold the fiduciary duties can expose employers to regulatory enforcement and private legal action. Fiduciaries may face fines, personal liability, and even bans from providing services to plans. The severity of consequences underscores the critical need for employers to diligently fulfill their fiduciary obligations. In navigating these challenges, employers should engage in a prudent process for selecting and monitoring service providers. Prudence equals process. This doesn't necessitate hasty changes, but calls for a cautious approach, understanding that one size really does not fit all. Each employer must tailor its benefit plans to the best interest of its own participants.